I call the honourable member Giles Chauvel.
Thank you, Mr Speaker. Mr Speaker, I'd just like to follow the Shadow Attorney-General's remarks by supporting the tenor of what he's just had to say. It was helpful to have the Attorney-General outline the bill as it's come back to the House. It is perhaps regrettable on a matter of this import that it appears we aren't going to have any more government calls in the debate, but nonetheless it is, I think, appropriate to use the opportunity that we have, a rare opportunity to discuss in this chamber security matters, to express the qualified support that the opposition brings to this third reading debate. As has been said, the Labor Party has decided that it will support the amendment, but just as the Shadow Attorney-General entered a couple of reservations to that support and perhaps look forward to some ways in which we might do things differently in this area, I'd like to expand on some of those thoughts. It is, first of all, a matter of real regret that the bill was read a first time under urgency. There is too much resort to urgency in this term of this Parliament, and urgency is an abuse of the procedures that exist normally in standing orders. They exist for a good reason. They exist because we don't have a second chamber. All we have by way of reviewing what the Executive brings into the House by way of legislation is the committee system, both the standing committees and the Committee of the Whole. If there is excessive resort to urgency, the danger is that those few safeguards that we have to scrutinise the laws that we are making properly are set aside. And we should take that a lot more seriously than we do. If we see further abuse of urgency, then we will also see a loss of confidence by the people in this place. And that's in nobody's interests sitting anywhere in this chamber. So, sir, I think what ought to be signalled first off is that certainly for my part, and I think for a number of my colleagues, it is appropriate to start thinking about ways in which we can better entrench the standing orders so that it is much harder to have resort to urgency, particularly where urgency involves avoidance of the committee procedure or circumscribing the committee procedure so that we can't do our jobs, the jobs the public expect of us, to have a look at the content of legislation in a proper fashion. So the second reservation that needs to be expressed around the process concerning this legislation is that the committee stages, as far as the Security Intelligence Committee or the Intelligence Committee of the House were concerned, were essentially at the behest of the government, heard behind closed doors. Now, I want to echo exactly what David Parker said on this point. There is no need for a default procedure to be adopted in any committee of this House. That secrecy ought to be that default. There are sufficient provisions in the standing orders for evidence to be heard either in secret or in private, so that any concerns around security or the identity of persons involved in the security apparatus or any other sensitive matter of national security can be adequately dealt with. And the fact that we didn't have the opportunity to have those provisions used as they should have been during this process is lamentable. As David Parker says, what that sort of process does is it gives rise to what is no doubt unnecessary suspicion amongst the public that something is being done here behind closed doors that ought to be being done with the disinfectant of sunlight instead. And when we do simply default to a private or a secret way of proceeding in the name of national security, we give rise to those fears and we feed them. We shouldn't, we needn't. There are, as I say, procedures in place that allow those matters to be sufficiently taken care of. They should have been had regard to in this circumstance, and they weren't. Now, sir, everybody on this side of the House concedes that the subject matter of this bill is important. It does involve a balancing act between the powers of the security agency to protect New Zealand interests on the one hand, with the rights, particularly the human rights and privacy interests of those both whom the service investigates and whom it protects. And it is certainly obvious that given the Principal Act dates back to 1969, it's 40 years old, 42 years old, it's long before the advent of cell phones, the internet, portable devices and social networking. So clearly there is a need to bring this sort of legislation constantly up to date to take account of modern technology. It's obviously also important to have regard to the security environment in which we live. And another matter of regret that I have is that it was thought necessary to rush this legislation through in time for the Rugby World Cup. We shouldn't do that sort of thing. This sort of legislation is too important to make it contingent on passage by a particular date because of a particular event. It should contain enduring principles that represent getting that balance that I've just referred to right, rather than saying, oh, we've got to get this legislation through before the Rugby World Cup. That is not an appropriate way, it's not a principled way to legislate on security matters. And Sarah, I think the other thing that it's appropriate to recall is that we are now 11 years on from the tragic events of 9/11. And I think it's fair to say that as a result of that 11 years having passed, we can be, or 10 years, we can be more dispassionate about threats on the one hand and the civil liberties that we're prepared to give up as a society on the other in order to protect ourselves from those threats. I think most people would acknowledge that in the shadow of those tragic events, we were all much too willing to give up the civil liberties side of the ledger and not have proper regard to the balancing exercise that ought to have been taken. It is appropriate to take time after those sort of events to think about the balance. And I wish that there had been more time and a more open process by which that could have occurred in this situation. So I think the most important change to the bill that I want to commend to the House that was made during the committee process, one that I've already said I don't think was a perfect or ideal one, was the insertion of a series of principles, working principles, in the legislation by which the work of the Security Intelligence Service should be carried out. It is significant that those principles have been inserted and that they were inserted at the behest of the Human Rights Watchdog, the Human Rights Commission in New Zealand. So that is something to be pleased about. So the bill updates existing powers. For that reason, it will receive support from members on this side, but it should be remembered that those powers are extensive. There is some oversight, as we've heard. There's the Select Committee itself. There's the requirement that warrants for domestic interception be granted jointly by the Prime Minister and the Commissioner of Security Warrants. We've had two very fine retired High Court judges serve in that capacity, Justice Naser and Justice Jeffreys. But so we should always be asking whether we've got sufficient oversight. We've got a combined agency here responsible for both domestic and foreign security matters. In Australia, ASIO is responsible only for the domestic side. It's supervised by the Attorney-General in a nod to an attempt to get better oversight and better control by the rule of law into the process. So we should clearly be thinking at all times about that balance to which I referred, our security on the one hand and our rights on the other, and we should always be asking whether we get that balance right. For the reasons that I've referred to, Sarah, I'm concerned that in this process we haven't, and we should always be mindful of the need to keep the principles by which we oversee security legislation relevant, not determine them by self-imposed deadlines relating to upcoming events. That's the wrong way to do it, and I hope, sir, that we haven't legislated in haste here in order to regret at leisure.